Good morning and welcome to this hearing in the Shekobio Public Inquiry. In this hearing, we will hear evidence from various witnesses currently or formerly associated with the Crown Office. The terms of reference as they relate to the Lord Advocate are subject to a limitation. The inquiry is required to examine the post-incident management process and investigation up to, but not including, the decision by the Lord Advocate as to any prosecution in the case, including the statutory review in respect of his decision. It is appropriate, therefore, that at this stage I give an indication as to how the inquiry should proceed in order to respect that exclusion. The inquiry will not examine the following: the prosecutorial decision and reasoning of the Lord Advocate, the prosecutorial decision and reasoning of Crown Counsel, the recommendations and advice given by the Procurator Fiscal in reporting the case to Crown Counsel, and which particular potential crimes the Lord Advocate, Crown Counsel, and members of the Crown Office and Procurator Fiscal Service considered could be relevant. Subject to these exclusions, the inquiry will examine the post-incident management process and investigation conducted by the Crown. I should just mention that Mr. Fuller, Assessor, is joining remotely this week. Could we have the witness in now, please? Good morning, Mrs. Carnan. Would you take the oath, please? I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Ms. Thompson.
Good morning.
Good morning.
Is your full name Fiona Carnan?
Fiona Ann Carnan.
And is that Mrs.
Yes.
Carnan? You are currently employed by the Crown Office and Procurator Fiscal Service.
That's correct.
For how long have you been in their employment?
38 years, I think, this
38
year.
years.
Coming up 38 years.
I think you say in one of your statements that you joined COPFS in or around 1986?
1986, that's right.
What is your current grade?
I'm a Principal Procurator Fiscal Deputy.
And what is your current role?
I have returned to criminal allegations against the Police Division.
Before we go any further, Mrs. Carnan, there's a blue folder beside you. Can I invite you to open that up and take a look, and I'll talk you through what's inside that folder. There are a number of documents. The first one, and we don't need to bring this up on the screen, but the first document should be a letter from the inquiry to you dated the 29th of August of 2023.
No, it's the 9th of January 24.
That's the second one. Well, let's begin with that. I understand that the inquiry sent you 2 letters, one on the 29th of August and then more recently on the 9th of January of 2024.
That's right.
And in both letters, which were in accordance with what we call Rule 8 procedure, you were asked to respond to a number of questions in writing.
Yes.
So it sounds as though they're perhaps in the wrong order, but let's begin with the one that's at the front of your folder. And that's the request that was made on the 9th of January of 2024. We'll bring it up on the screen. It has the reference SBPI 00436. So I just want to check that this is what you have in the folder.
Yes.
in front of you. This is the letter of the 9th of January. It explains that it's a request made under Rule 8, and we don't need to concern ourselves, I don't think, with the content beyond that. Now, your reply to that Rule 8 request will hopefully be behind the request itself in your folder. It's got a reference number 00462.
Yes.
If we could bring that up on the screen also, please. So this is the response that you gave in writing to the letter that you received on the 9th of January of this year. And if we scroll to the bottom, we'll see that you answer the questions in 32 separate paragraphs, and that the response was signed by you on the 13th of February of this year. Now, your signature has been blacked out in the copy on the screen, but will hopefully appear on the copy in your folder.
Yes.
If we can look at the final paragraph of the statement, please. It reads, "I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website." When you prepared your answers to the questions that were asked of you, did you do your best to provide a full and accurate response?
I did.
Now, this is strictly speaking a response to a Rule 8 request, but I will probably slip into the habit of referring to it as your second statement. I'm hoping that next up in your folder then might be the first Rule 8 request that was made of you. And that was my letter dated the 29th of August of 2023.
It looks like the next document is SBPI 00379, which is my response.
Which is your reply. Well, let's bring that up on the screen, because I think what you did, which I think perhaps makes life a lot easier for everyone, is you copied over the questions.
Yes.
And then you appended your answers
Yes.
beneath them. But you can perhaps take it from me that the letter that you were sent was dated the 29th of August, and we see on the screen before us now your reply to this first letter. So again, I will probably refer to this as your first statement. And if we can scroll to the bottom of this document, it's a longer document, it's 32 pages, that's 91 paragraphs. We see that you signed it on the 11th of October of last year.
Yes.
And again, is your signature visible on the copy that's in your folder?
Yes.
The final paragraph is in identical terms to the second statement that we looked at a moment ago. And again, when you answered the questions, did you do your best to do so fully and accurately?
Yes.
Now, also within the folder, there should be a copy of the narrative and analysis from the Crown Precognition. We don't need to bring these up on the screen. I'd just like to know that you have them before you, because you can refer to them at any time if you would find that helpful.
Yes. I can see them.
So you have both the narrative and the analysis there.
I've got the analysis first, then the supplementary report, and then behind that it looks like the narrative.
All right. So they're maybe a little bit out of order, but they are all there.
Yep.
That's grand. You mentioned a supplementary report. That was the report that considered the health and safety aspects of the case. So that's in there too. And finally, I'm hopeful that there will also be a document there that you asked to have available today called Fiona Analysis, which
yes. I see that as well.
That's there as well.
Multicoloured, yes.
That's great. So you can refer to these documents at any point in time.
Thank you.
I will bring up on the screen any paragraphs of any of the documents that I want to refer to. If there's anything you want to draw to my attention, just say, and we can have it brought up on the screen as well. Mrs. Carnan, when did you qualify as a solicitor?
1982.
And we've already established that you joined the Crown Office in 1986.
That's correct.
And that would have been as a Procurator Fiscal Depute.
That's right.
When were you promoted to Senior Depute?
Well, I was on a temporary promotion. I'm not sure the year, maybe 2017, 2018. And then made permanent in 2021, I think.
You said earlier in your evidence that you're currently a Principal Depute,
Yes.
so that's a grade above a Senior Depute.
That's right.
And when were you promoted to Principal Depute?
That so as I say, 2017 or 18 on a temporary basis, and 2021 on a permanent basis.
Oh, I beg your pardon, I thought you had been promoted to Senior Depute and then Principal Depute.
Senior Depute, I can't remember when that was. I was a senior legal assistant from about 1991, and I think that was then regraded or renamed as a senior deputy, so I don't think there was any actual promotion involved in that. Might be wrong, but I don't think so.
It may not matter at all. I'm just trying to understand your career progression within the Crown Office.
Yeah.
And as you say, certain of the bands have been rebranded
Yes. along
along the way, which perhaps makes it more complicated. But in any event, during the period of time that we are concerned with, which is sort of 2017 into 2018, you would have been a senior depute.
Yes.
And at some stage, you had a temporary promotion to principal depute, and
Yes.
that has since been confirmed
Yes.
on a permanent basis. I wonder if we can bring up the first of your statements or Rule 8 responses on the screen, please. And in your response to the first question, you explained that during your involvement in the investigation and precognition process in the Shekobayo case, you were a senior depute in the criminal allegations against the police division. You had been in the same grade and role since the end of 2012 when that specialist division was set up. And you explain, my duties and responsibilities were to investigate reports of allegations of criminality by serving police officers and members of police staff, and, where appropriate, to report to Crown Counsel to obtain instructions as to whether to prosecute or not.
Yes.
Am I right to understand that that investigative process is known as precognition?
Yes, it can be.
And the person who carries out that process is sometimes referred to as a precognoser.
Yes.
Now, there's evidence before the Chair that the Lord Advocate is the ministerial head of the system of prosecution in Scotland, and he or she is also responsible for the investigation of all sudden, suspicious and unexplained deaths, including deaths in police custody. Would that be correct?
Yes.
Now, the Lord Advocate cannot personally prosecute every case that proceeds in the High Court, and so she appoints Crown Counsel, also known as Advocate Deputes, who conduct prosecutions in the High Court in her name. And Crown Counsel also take decisions on the Lord Advocate's behalf. Is that right?
Yes, that's right.
And in more serious cases, it would be Crown Counsel who would decide whether or not there should be a prosecution.
That's right.
And that would include, for example, a death in police custody or following police contact.
Yes.
And that decision would be taken by Crown Counsel after they had considered the precognition report prepared by the precognoser. Now, am I right to understand that when the matter under investigation involves a death, the precognition would ordinarily be carried out by the Scottish Fatalities Investigation Unit?
I think that's right, yes.
Where there's a death in custody, however, which raises the possibility of criminality on the part of police officers, then the precognition process may be carried out by the Complaints Against the Police Division, or CAPD.
I think this was the first such case, so I'm not sure there was any precedent for it, but certainly that's where this investigation sat.
In either case, at the conclusion of the precognition process, a report is submitted to Crown Counsel,
Yes.
and Crown Counsel will then issue an instruction as to whether there should be criminal proceedings brought or not, as the
Yes.
case may be. Now, the investigation of a death, of course, is not just about whether there should be a prosecution. Consideration will also have to be given to whether there should be a fatal accident inquiry.
Yes.
And such inquiries can be mandatory or discretionary under the relevant legislation. And a death in custody would be a mandatory fatal accident inquiry.
That's right.
A death can also, in certain circumstances, lead to a public inquiry, as has happened here. So should we understand that at the conclusion of an investigation into a death, Crown Counsel may instruct that there should be a prosecution or a fatal accident inquiry, or they might instruct that there should be no proceedings at all.
That's right.
I'd like to ask you a few questions about the precognition process, just to set the scene for the benefit of anyone listening to this chapter of evidence. Can you help me to understand what the precognition process involves?
I think it will vary from case to case, but the actual act of precognosing witnesses is often involved, and that involves seeing witnesses and taking a statement from them.
And what does the act of reporting to Crown Counsel involve?
It involves essentially a narrative of what happened, setting out the circumstances, and a legal analysis in terms for criminality, and a legal analysis of whether there's sufficient evidence for proceedings. There would also be ancillary information about an accused person or potential accused person. And in this particular case, the potential accused were what we call the subject officers, the officers who were potentially subject to criminal proceedings, so those that might have in some way acted in a criminal way.
So the report will comprise a narrative of the facts, an analysis of the evidence,
Yes.
and is there also a recommendation
At the end.
at the end of the analysis
Yes,
section?
and that will depend on what the analysis of evidence is.
And these documents, or these chapters of the report, are drafted by the precognoser
Yes.
and signed by the precognoser and by countersigned by the solemn legal manager.
That's right.
Now, what is the purpose of the narrative section within the report?
To set out the facts as known,
And what is the purpose of the analysis?
to apply the law to those facts, and to, in particular in relation to a CAPD precognition, it would be to identify criminality if there was criminality, and to consider whether there's a sufficiency of evidence in relation to any matters.
And what would be the purpose of the recommendation section?
It's almost a conclusion. It's a follows on from the analysis. It's a conclusion and a recommendation as to whether there ought to be or not criminal proceedings.
Are the witness statements and precognitions appended to the precognition report?
So the witness statements taken by the investigative agency, plus any precognitions taken by precognosers, would be included in that report.
And any report submitted by an investigative agency?
Sorry?
Any report?
Yes, that would be also included.
So typically the police, but in this case it was the PERC, or the
That's right.
investigative agency, so that would be included too. And
That's right.
copy productions, are they also appended to the report?
Yes.
I want to touch on compliance with the ECHR before we go any further. The Lord Advocate's investigation into death, which is sudden, suspicious or unexplained, has to be Article 2 compliant.
Yes.
And we'll look shortly at what that means. And that would include a death in police custody or a death following police contact. And where there's a possibility of racial discrimination, the Lord Advocate should also have regard to Article 14 of the ECHR. Is that right?
Yes.
And just as the Lord Advocate cannot personally prosecute every case that proceeds in the High Court herself, nor can she personally investigate every sudden, suspicious or unexplained death, and she discharges her duty to conduct an Article 2 compliant investigation through the process of precognition and reporting to Crown Counsel.
Yes.
Do I understand
Yes.
the mechanisms correctly? I want to ask you a few questions about your experience as at 2017, when you became involved in this particular investigation. As at 2017, what experience did you have of preparing precognitions for Crown Counsel?
I had quite considerable experience over the period of my service. I was involved in preparing solemn cases, High Court precognitions, some death precognitions, not that many, and I had from 2012 experience in CAPD precognitions.
Could you put a number on how many precognitions you prepared?
I don't think so. I'd be guessing. Probably hundreds, but I don't know.
All right. And what experience did you have of investigating deaths? You mentioned having done some precognition work and having been in CAPD since 2012. What was your deaths experience?
It was varied. I remember starting as a young deputy in Lisco, and I would have some death investigations then. When I moved to Glasgow in 1998, I was in different units depending, so I would be in summary or solemn criminal units. Probably my experience then in relation to deaths was late 90s, early 2000s when I was in Hamilton. I was certainly working in deaths for a period.
Did you have any previous experience of investigating a death in custody?
No,
No.
not at that time.
And I think you make that clear at your answer to question 4 in your statement, where you say that prior to the date you became involved in this matter, I had no previous involvement in the investigation of deaths in police custody or deaths following police contact.
That's correct.
What experience did you have of investigating whether race was relevant to the circumstances of a death?
Probably quite little, because I don't recall.
Yes. I think you say at answer 5, if we can scroll down just a little bit, that you don't, very final sentence, you say you do not specifically recall any deaths when race was a factor, although there may well have been during the course of your
I've no recollection
career.
of dealing with deaths in which race was a factor.
All right. Did you have any experience of, through your time in CAPD, of investigating allegations of excessive or unlawful use of force by the police?
Yes.
Can you share with us the range of experience that you had in relation to that type of investigation?
I would say probably the majority of complaints made against police officers involve excessive force. They would be reported to the criminal allegations against the police division if there was an inference that the officers had committed an assault, and the assessment would be made as to whether there was evidence of that.
Did you have experience of instructing experts on the use of force?
Yes. It was commonly the case that either professional standards or PERC would instruct an officer safety trainer to provide an opinion, and if they didn't, it was the practice of myself or my colleagues to do that, so that we had an opinion on those matters.
And how many previous occasions had you instructed a use of force expert? Can you say?
Many, but again, I'd be guessing to give you a figure, I'm sorry.
That's all right. Let me ask you about the training that you received during your time in Crown Office up to 2017. Had you received training on the Precognition process, the nuts and bolts of what was required?
I think it was very much an in-office training. I certainly don't recall going to a formal training course on Precognition. I think my reference to training, I think you've asked me at some point, and I think I've said I recall attending a child Precognition training course. But my training was given by senior colleagues. So when I first started, my boss would have shown me a Precognition. This is how you do it. This is how you produce the report.
What training had you received on investigating deaths in police custody, if any?
Specifically deaths in police custody. I don't recall any training specifically on that.
Had you received training on the investigation of deaths more generally?
Again, my training record, I think I look back at that to answer these questions, and I think I attended a course in the year 2000.
Do you recall what that covered at this distance?
No, frankly, no.
And had you had any training on the requirements of an Article 2 compliant investigation?
I don't recall specifically, no.
Had you had any training on investigating whether race played a part in the commission of a crime?
I don't remember training in that regard, no.
Had you had any training on instructing expert witnesses?
No, I don't think so. But again, learned through experience.
Had you had any training on ensuring compliance with Article 14?
I don't recall specific training on that either.
Now, you say in your statement at paragraph 47, please, you say that prior to your involvement in this case, you had no awareness of investigations by the police or CPS into race in England and Wales, other than what had been reported in the press, or what you had read in relation to reports of English cases. Although you also say in paragraph 48 that you had read the report of the IPCC investigation into Sean Riggs' death before submitting the Precognition report in May of 2018, and you go on to set out what you understood the learning points were from that report, and you say that you took them into account in the work that you did in connection with the death of Sheku Bayo. I wanted to ask, how did the Sean Rigg report come to your attention?
I think Mr. Brown, who's my line manager, wrote it to my attention.
Did you consider any other reports?
I don't remember. I think Thomas Orchard might have been another one, but I'm not sure. Sean Rigg certainly was brought to my attention.
If we can scroll down to paragraph 49, please. You say that you understood that Mr. Brown, that's Les Brown, who you explain was your line manager at the relevant time, and Ms. Edwards, Casey, consulted with the CPS about their approach to deaths in custody, but you weren't involved in that exercise.
That's right.
Was there learning from that exercise shared with you?
I saw the notes of the consultation afterwards.
What sources of guidance and information were available to you in terms of how to investigate a death in custody?
My experience probably, but the Knowledge Bank, which is available on the intranet in Crown Office, contains a range of materials.
Tell us more about the Knowledge Bank.
Knowledge Bank, lots of case law, case marking guidance about particular offences. Back when I started, it would have been the Book of Regulations. That was, if I can call it, it's almost like the Bible or the kind of standard, and that would be your first port of call. But since then, many other manuals. For example, I think there's a solemn case manual. There are all sorts of different pieces of guidance.
The Knowledge Bank, I think you said it was accessible on the intranet.
That's right.
Was it available as a hard copy document?
No.
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 What sources of guidance and information were available to you as to how to approach the question of race?
Well, the question of race was one that was a matter. Well, what I was looking at was criminality. So race didn't really feature in that because criminality hadn't been identified.
If you can hold that thought, because I would like to ask you about your approach to race and how that fitted with criminality in quite a lot of detail, but we'll perhaps come back to that after we have considered a number of other issues. And for now, I'm really just trying to get a feel for the range of materials, guidance and information that were available to you. So you've explained that race didn't really feature in your analysis in this case.
Yes.
Had you ever required to consider race in connection with any other case?
I'm sure I did.
And can you help us to understand what resources and guidance and information were available to you that might help you as a precognoser if you are looking at race?
Well, it would, in relation to criminality, it would be the provisions of, I think, it's the 2015 Act. I'd need to go and check what Act it was, but there are provisions under 2 sections in relation to racial harassment and acting with racial prejudice.
Okay. So there's the legislation, but in terms of guidance as to the approach that a precognoser might take when investigating race, where might you look?
Again, I'm sure there would be documents on the intranet.
Okay. And what sources of guidance and information were available to you on how to ensure that the precognition process was compliant with Articles 2 and 14?
I think as far as Article 2 is concerned, it would be the basic provisions about carrying out a thorough and timely investigation that would apply to all these cases. Article 14, I'm not quite sure.
And if a precognoser, for example, were looking at race for the first time, where would they go to find guidance and information?
I suspect the Knowledge Bank.
Okay. Now, you mentioned the Book of Regulations, the Fiscal's Bible. What's the purpose of the Book of Regulations?
The Book of Regulations was a manual provided, as I say, way back when I first started. It was simply guidance. It was guidance on all manner of activities that a fiscal would have to look into, so deaths, criminal investigations.
You're using the past tense when you speak about the Book of Regulations.
I'm not sure if it's still in existence or whether, certainly some chapters have certainly been superseded. I'm not sure if there are some chapters of the Book of Regulations that still apply.
I wonder if we can look at one chapter, and it's chapter 4.6, which deals with precognition, and the reference is COPFS 05648. So this is a section of the Book of Regulations headed Effectiveness, Chapter 4, Precognition and Management of Solemn Business. Generally, precognition and investigation must be focused on the main issues of the case and the evidence against each accused accurately represented and properly evaluated. All relevant legal issues, including those relating to convention rights, must be properly addressed, considered and recommendations made to allow informed decision as to further proceedings. So this chapter seems to be focused on the nuts and bolts of the precognition process. Is this the sort of information that nowadays you would find on the Knowledge Bank, or is the Knowledge Bank more about case marking guidelines legal tests, case law, that sort of thing?
This should be, and I suspect is in the knowledge banks. The knowledge bank is the place where all of this is, all guidance is stored.
Okay.
So I suspect this is in the knowledge bank.
So as at 2024, the knowledge bank is a single...
It's a library almost.
Okay, it's a library, and it's the place that you would go to look for information.
Yes, electronically.
Electronically, and that's where a fiscal would look for information about case marking guidelines,
Yes.
the law,
Yes.
case law, and
Yes.
also the procedural aspects of their job.
Yes.
What was the position back in 2017? Where would one have looked back then? Would it have been the Book of Regulations or the Knowledge Bank? Or
The knowledge
somewhere
bank
else?
would contain the information.
Okay. We don't have the Knowledge Bank, but we do have some chapters from the Book of Regulations. Let's look through this chapter, and if anything in this appears to you to be outdated or has fallen by the wayside, please let me know. Is there anything in the first paragraph that we've looked at that to your mind seems to be out of date?
No.
Okay. If we scroll down, the next heading deals with the responsibility of the fiscal. Area fiscals together with the district fiscal, and perhaps that language will be out of date.
I think so.
Again, there will be rebranding in terms of
Structural organisation. Yeah.
are responsible for ensuring that the precognition process is managed to ensure that all cases falling within their jurisdictions are investigated effectively in accordance with the Precognoser's handbook. So there's a reference there to another document that we've not discussed yet called the Precognoser's handbook. Is that one that you know about?
I do know about it, yes.
And is it still in existence?
As far as I know, yes.
Okay. And again, the information that's within the Precognoser's handbook, would you expect nowadays to find that information on the Knowledge Bank as well?
Yes.
Let's see what it says about the Precognoser's handbook. We're told it contains best practice guidance in the following areas of work which are relevant to effective investigation, and then follows a detailed list that includes things like management of precognition, taking precognitions, sufficiency of evidence, format, expert witnesses, and racially aggravated offences is near the bottom of the list, I think. And so on and so forth. And if we carry on beyond the bottom of that list, there's a reference made to a number of annexes which provide pro forma documents to assist solemn legal managers and precognosers. And there's a statement that all relevant legal issues, including those relating to departure from the guidance set out in the Precognoser's handbook, must be fully justified in each case, either to the area fiscal or if reported to Crown Office to Crown Counsel. So there's a statement there that requires compliance with the Precognoser's handbook. And if we scroll just a little further, we'll see that this advice in the Book of Regulations is dated November 2003. And as you've explained, nowadays, if you were looking for guidance on how to carry out a precognition, you would look to the Knowledge Bank rather than the Book of Regulations.
Yes.
But beyond the restructuring and rebranding of job titles and descriptions that we've identified, is there anything in that document, to your mind, that appears to be out of date or out of step with current practice?
No.
So the Precognoser's handbook is another document that you're familiar with. To the best of your knowledge, it is still in existence, though probably also accessible on the Knowledge Bank.
Yes.
What would be the purpose of the Precognoser's handbook?
To provide guidance on how to carry out and report precognition.
And we see from the Book of Regulations that there's an expectation that precognosers should follow any guidance in the Precognoser's handbook, and that departures from that guidance should be justified. Are you familiar with another Crown Office publication called the Deaths Manual of Practice?
Yes.
Okay. Can you tell us about it?
It's a manual, I think as probably the title suggests, it's a manual which gives guidance on the investigation of deaths.
And again, would you now find the information that's in the Deaths Manual on the Knowledge Bank?
Yes.
Does it exist as a separate standalone manual?
As a printed document,
Mm-hmm.
no idea.
Okay.
We're talking many, many years ago when many of the offices, what we call the hard copy books, started to disappear and everything was was available online, and that was the where we were directed.
Do you recall at this distance, back in 2017, 2018, when you were involved in this investigation, whether you at any point drew on information and guidance that was contained within the deaths manual?
No, I don't think I did.
Or the Precognoser's handbook?
I don't think I did.
Or the book of regulations?
I don't think I did.
Did you go to the knowledge bank at all?
In relation to the, this is likely to be in relation to the case law in relation to assault and culpable homicide and health and safety legislation.
And were there any other sources of information and guidance available to you in 2017 that we haven't discussed?
Very likely, but I don't know what they are. The knowledge bank contains many different pieces of guidance.
Tell me about the role of the solemn legal manager or the line manager in providing guidance and direction to a Precognoser.
I think it would depend. I'm thinking of solemn legal managers in a sheriff and jury team where the Precognosers might be non-legal, so might be paralegals, precognition officers, and that might be an entirely different experience to a solemn legal manager dealing with a procurator fiscal deputy or a senior deputy. So I suppose it would depend on the relationship and the knowledge and experience of each of the parties.
So a fiscal deputy or senior deputy will be a qualified solicitor,
Yes.
and they'll have a law degree,
Yes,
whereas a Precognoser won't necessarily have that background. Is
that's
that
correct.
Now, the Precognoser's handbook includes as an annex a guidance document, and I wonder if we can look briefly at this. It's COPFS 06454. Is this template familiar to you?
No,
No.
not particularly.
Let's look at it very briefly. Precognition guidance note, case against, I presume you would put in the name of the accused or potential accused there, reference number, identification of the Precognoser and their manager, likely prosecution forums, that might be High Court or Sheriff and Jury, provisional date for the case, and then internal target dates for completion of certain stages of the work. Then if we scroll down, it says guidance. The following directions are for your assistance. Please revert to your supervisor if there are problems in carrying out the instructions and if any problems arise in the case. Further, if during the precognition process it becomes clear that the case should be reduced to summary or that the likely forum specified above should be changed, you should speak to your supervisor. So this appears to be a document drafted by the manager for the benefit of the precognoser. Would that
Yes.
seem to be correct?
Yes, and I've seen this document, but it's not a document that I would have used myself, or it was used in CAP division certainly, so it would be used in solemn teams in terms of preparation of sheriff and jury and high court work.
I see, so this wouldn't be relevant to CAPD.
It wasn't used in CAPD.
Did CAPD have an equivalent template?
CAPD, when it first started, had some kind of instruction note issued by legal managers to precognosers. Not necessarily all of the headings there would be included, but there would be something about factual issues, legal issues to be addressed, and the amount of detail that would be included in that would very much depend on who it was being issued to, I would say.
I see. So this template is for solemn criminal work, not for CAPD,
It
but
wasn't
something similar to this,
Yep.
what was in use. And I can see straight away that some of the headings simply wouldn't be
No.
relevant in the context of a complaint against the police. But you say that something similar would be prepared, and it would cover things like factual issues to be
Yeah.
addressed and legal used to be
Yes.
addressed. So CAPD had its own version of this form,
Yes.
and you say that the amount of detail that might be included in the form would very much depend on who was on the receiving end of the form, and would that in turn depend on whether they were inexperienced or inexperienced, and potentially whether they had a law degree and were qualified solicitors, or had perhaps come to precognition work through a different route?
Yes.
We can take that away from the screen just now, and I want to speak to you about the investigation of Article 2 deaths. So I'll give you a moment just to pour some water. I want to read to you a very short extract, which I anticipate will be familiar to you, from a case called Da Silva, which sets out what is required for an investigation to be Article 2 compliant. The court has, in its case law, established a number of requirements for an investigation into the use of lethal force by state agents to be effective. In summary, those responsible for carrying out the investigation must be independent from those implicated in the events. The investigation must be adequate. Its conclusions must be based on thorough, objective, and impartial analysis of all relevant elements. It must be sufficiently accessible to the victim's family and open to public scrutiny, and it must be carried out promptly and with reasonable expedition. Is that quotation familiar
Yes.
to you? And would you disagree with anything that is in it?
Absolutely not.
And I wonder if we can look briefly at the Deaths Manual of Practice, COPFS 06186 at page 2, where there is a summary which I think perhaps draws on Da Silva. And you can take it from me that the identical language appears in the Book of Regulations in chapter 12.01, which is the investigation of deaths. So let's look at this, because this is in guidance that was available and perhaps would also have been on the knowledge bank. Article 2 of the European Convention on Human Rights provides that everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. The right to life implies certain obligations on the state to undertake an effective investigation, which is independent, effective, reasonably prompt, open to a sufficient element of public scrutiny, and one in which the next of kin must be involved to an appropriate extent. These considerations should be central to all deaths investigations undertaken by COPFS, and all decision-making and reporting should demonstrate how the Article 2 requirements of an effective investigation have been taken into account. Further guidance on Article 2 and its requirements is available on the Knowledge Bank, and work is underway to mainstream Article 2 requirements throughout COPFS policy, practice and guidance. So were you familiar with this sort of statement within Crown Office
Yes.
policy and procedure? And in particular, were you aware of the requirements that Article 2 considerations should be central to all deaths investigations, and all decision-making and reporting should demonstrate how the Article 2 requirements of an effective investigation have been taken into account?
Yes.
Okay, we can take that away from the screen, thank you. So we see then that for an investigation into a death by Crown Office to be Article 2 compliant, it requires to be effective. Would you agree with that?
Yes.
Yes. And to be effective, the investigation must be adequate.
Yes.
Now, where a death follows the use of force by state agents, an adequate investigation must be capable of leading to a determination of whether the force used was or was not justified.
Yes.
And the standard to be applied is that of no more than absolutely necessary. Are you agreeing with that too?
Yes.
And further, when the death is at the hands of state agents, and taking Article 14 in conjunction with Article 2, the authorities have an additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events. Would you agree?
Yes.
And would you agree that where there's a suspicion that racial attitudes have induced a violent act, it's important that the official investigation is pursued with vigour and impartiality?
Yes.
I want to turn now to ask you about your involvement in the investigation within the Crown Office that followed the death of Sheikh Bayo. So Mr. Bayo died on the 3rd of May 2015. The Crown instructed the PERC to investigate, and the inquiry has heard some evidence about that already.
Yes.
And the PERC's final report was submitted in August of 2016. And although there was contact between the PERC and the Crown between May of 2015 and August of 2016, am I right to understand that it was only after the final PERC report was submitted to the Crown that the formal process of precognition began?
I don't think I can really comment because I wasn't involved until
All right.
late 2017.
Well,
But I think that's right, but I think others might be able to confirm better than mine.
we can ask other people about that, but in the ordinary course of things, would you wait until you received a report from the investigating agency before commencing the precognition?
Yes.
You've explained that you didn't become involved until December of 2017.
That's right.
And the precognition report was sent to Crown Counsel in May of 2018.
That's right.
So 5 or 6 months later. Now, I understand from reading your statements that your involvement went beyond May of 2018 in certain respects, but I want to focus on that period between December of 2017 and May of 2018 in your evidence today. And we'll also hear evidence later this week from Les Brown, who you've mentioned was your line manager. Was he your line manager throughout that period?
Yes.
That he was involved from 2015 until 2019, so both before, during and after
That's
your
right.
involvement in the case. Can we bring up on the screen, please, your second statement, your second relate response? Can we look at paragraph 2, please? You were asked to explain the process that was followed. You were referred to the supplementary report. That's the one that deals with the health and safety aspects.
Yes.
And you explained that you drafted that, and you did that separately after the precognition report containing the narrative and analysis of the evidence had been submitted to Crown Counsel.
Yes.
Sorry, bear with me just a moment. I think I have the wrong reference. I'm so sorry, that's my fault. It's a second statement, but paragraph 1. We may return to the second paragraph. You were asked to explain your involvement in preparing the narrative and analysis.
Yes.
And you say, I was asked to become involved in the investigation in December 2017. Part of my remit was to assist my colleague Alistair MacLeod in the preparation of an analysis of evidence for the precognition report to Crown Counsel. By that time, Alistair MacLeod, who had been involved from an earlier stage, had already started to draft a narrative of events, which was well progressed by the time I joined the team. He had also prepared a separate timeline which supplemented the narrative. From memory, some parts of the narrative were contributed by me, such as the complaints history of the subject officers, sections on police training, and references to Martin Graves' report, results of the analysis of Ashley Wise's mobile phone, and the section about further investigations.
Yes.
Some parts of the draft narrative contained elements of analysis within it, and I proposed with Alistair's agreement that I would remove those parts and work on the separate document, the analysis of the evidence. I adapted some sections of Alistair's analysis to inform my analysis, but expanded that analysis to the final version that was sent to Crown Counsel. It was an evolving process. We tended to work separately, with Alistair working chiefly on the narrative and I on the analysis of evidence, although sharing these with each other regularly, discussing and cross-checking with each other at regular intervals. The precognition report comprising the narrative and analysis of evidence was signed by me, Alistair MacLeod and Les Brown, and submitted to Crown Counsel in hard copy format, along with the volumes of statements, precognitions and associated copy productions. And then at paragraph 2, which we've already looked at on account of my error, you explain that you also drafted the supplementary report. It was done separately after the Precognition containing the narrative and analysis was submitted to Crown Council, and the draft report concerned potential health and safety charges against Police Scotland and included an assessment of whether there was evidence to support a charge of corporate homicide.
Yes.
So that's a summary of your involvement in this case. Now, if we can scroll back to the first paragraph, we see that you say that Alistair MacLeod worked chiefly on the narrative and you on the analysis. So you worked collaboratively, you worked together, but he
Yes.
led on the narrative and you led on the analysis.
Yes.
And you say, if we can perhaps jump to paragraph 26, please. I beg your pardon, I think it's paragraph 26 of the other statement, but I'll read it to you. I don't think we need to bring it up on the screen. It can be quite confusing when you've got a number of statements. I am sorry. But in your first statement at paragraph 26, you say, it was not part of my remit from Les Brown to consider whether there were grounds for an FAI. My role was restricted to an analysis of the evidence in respect of any potential criminality by the police.
Yes.
So your remit was a limited one. It was an analysis of whether there was evidence of criminality by the police.
Correct.
And you also considered health and safety and corporate
Potential
homicide issues too. So if not you, then who, if anyone, was tasked with considering whether there should be an FAI?
I don't know.
Do you know whether that consideration, that analysis, was in fact carried out?
I was aware that criminality was the first consideration. I was aware, and I couldn't tell you at what point I became aware, but I was aware that there was a view that there would either be a fatal accident inquiry or a public inquiry, but I don't know at what point I became aware of that. It was discussed at points, but I really couldn't tell you about the timing of it.
Now, I understand that Les Brown, in one of his statements to the inquiry, talks about taking an incremental approach, and the first report that was submitted to Crown Council focused on criminality, and he explains that the question of an FAI would wait until a decision had been taken in relation to criminality.
Yes.
Was that your understanding of the process that was being followed?
That would always be the process. There wouldn't be a fatal accident inquiry or consideration of that until questions of criminality had been considered.
So these matters would always be considered
First.
Separately, with criminality being
always first.
Always first. And then there may be, I assume, a supplementary report to Crown Council addressing the question of a fatal accident inquiry in circumstances perhaps where Crown Council had instructed there shouldn't be a prosecution, or at the conclusion of that prosecution.
That's right. And certainly my experience in SFIU following my involvement in this is exactly that. So questions of criminality are always addressed first, and then sort of SFIU is at the bottom of the pile, if you like, in terms of what report comes, and then it would always be that an FAI would be the last consideration following any other proceedings.
So there's nothing unusual then in the fact that the possibility of an FAI wasn't addressed in the narrative and analysis that were submitted to Crown Council.
Nothing unusual in that at all.
And would you agree that certain aspects of your analysis, for example, your analysis of use of force and cause of death, would be relevant equally to consideration of criminal proceedings and the appropriateness or otherwise of an FAI?
Yes.
If we can look at paragraph 3 of this statement, please. you explain that the purpose of the Crown narrative was to provide a factual account of the events, together with relevant background information and the provision of other material connected to the investigation that was deemed relevant. The purpose of the analysis that accompanied the narrative was to provide a legal analysis of the available evidence, addressing the question of whether the evidence disclosed any criminality on the part of the officers involved in the incident in which Mr. Bayo died. And the purpose of the supplementary report was to provide a legal analysis of potential criminality under the Health and Safety at Work Act, or in relation to the Corporate Manslaughter and Corporate Homicide Act.
Yes.
And you, earlier in your evidence, explained in general terms the purpose of a narrative, an analysis, and a recommendation. Now, the final page of the analysis that includes the recommendation has been signed by you, by Alistair MacLeod, and also by Les Brown, who was your line manager and I think also head of CAPD at
That's right.
the relevant time. What was the purpose of you signing the Precognition report before it was submitted to Crown Counsel?
It's certainly the practice. I think it simply confirms that you're responsible for it. You take responsibility for your work.
And what's the purpose then of your line manager also signing the Precognition?
And that he also confirms that he's read and agrees with the report.
Now, when you became involved in December 2017, what guidance, if any, were you given as to the issues that were to be addressed in your analysis?
I'm not sure I was given any guidance about the issues. I was simply told that I was to become involved. I don't have a written record of it, so I don't think there is a written record of any guidance by Mr. Brown. I understood it was in relation to a death in police custody, and I had to carry out an legal analysis of the evidence. I think during the course of my work, I received various emails from Mr. Brown about the issues that he wanted to ensure were addressed, and I think I did that.
And what guidance, if any, were you given as to how to ensure your work was Article 2 compliant?
I was asked to look at the cases, and I think Sean Rigg was one that I particularly looked at. I recall being asked to read the report by Dame Eilish Angelini and to ensure that the investigation was thorough, which I think it was, in relation to my work.
And what guidance, if any, were you given on how to approach Article 14 in your work?
I don't recall any particular guidance on that.
Now, I wonder if we can look at the Precogniser's Handbook again, Chapter 1, which is COPFS 05666. Pre-allocation. Prior to the allocation of the case for preparation, it must be read by the solemn legal manager, or in accordance with arrangements authorised by the area fiscal, an appropriate experienced member of legal staff. So again, we can see straight away that some of the job roles have been rebranded, and to that extent this must be out of date.
Yes.
And if we can scroll down to page 3, please. There's a section headed the allocation note. The solemn legal manager must give appropriate guidance to the precognoser. The guidance should include advice or instruction on which witnesses should be seen and the extent of the interview required, in accordance with the principles of purpose-driven precognition and any legal principles that may apply. Now, we looked earlier at the annex to the Precognoser's Handbook, and it was a pro forma, which you explained to me was used in solemn legal business, not in Cap D, but Cap D had some sort of equivalent form. Is the form that we looked at, albeit that was the one for solemn proceedings and not for Cap D, is that a sort of guidance note or allocation note? Was that the sort of thing?
I mean, an allocation note traditionally in Cap D would involve some analysis or some direction as to the issues that should be looked at. I think that would be fair.
And did you receive any allocation or guidance note here? You said you didn't have.
I didn't have anything in writing from Mr. Brown. It was a meeting with him, and as I say, over the course of my work, there were emails that he sent me in terms of what issues he wanted me to ensure that I covered.
Now, as discussed, the Precognoser's Handbook may be out of date nowadays, and even in 2017 you go to the Knowledge Bank. Is there anything that we've looked at in this particular chapter that jars with you as being out of step with the way that things are done in Crown Office?
I don't know what happens in High Court units and Sheriff and Jury units these days. It's a long time since I've worked there, so I really am not able to comment. I can tell you what happens in Cap D, but that's about it.
Well, that's very helpful because it's Cap D that we're interested in. Yeah. I had understood, perhaps wrongly, that the Precognoser's Handbook would apply to all precognition work, irrespective of which unit was undertaking that work, or that the principles would carry across.
I think the principles carry across in terms of what forms are used and how, as a process, the work is managed. I think it's a bit different in Cap D.
Thank you. Now, I have had access to a minute prepared by Mr. Brown long before your involvement in the case, and I'd like to pull that up. I'm interested to know whether you ever saw it, and if you didn't, there may be good reason for that. But for completeness, I'd like to show it to you. It's COPFS 03853A, and it's a minute dated the 15th of September 2016. So that would have been not long after the PERC report was received in Crown Office. You can see that it's come from Mr. Brown and has been sent to a number of individuals within the Crown Office, including Alistair MacLeod, who of course was the Precognoser, and you mentioned in your statement he'd been involved from the outset, and Ashley Edwards, who was the allocated Advocate Depute. Meeting at Crown Office, Reshekubayo, purpose to identify key issues to be explored at precognition of relevant eyewitnesses to actions of police officers engaged in the restraint of Shekubayo. And a little bit of background, and if we scroll down to the discussion, this is where Mr. Brown mentions the incremental approach. An incremental approach to the investigation and decision-making process has been proposed. Essentially, the first part of the investigative process will be focused upon reaching a decision as to whether there is any basis for taking criminal proceedings against any individual police officer involved in the restraint of Mr. Bio. So that chimes with your understanding of the way that things are typically done. And if we scroll down a little, please. Keep going, please. To this list of bullet points. Without wishing to be prescriptive, I would suggest that the following critical issues require to be explored during the precognition process. And if we read these bullet points short, they relate to Mr. Bio's actings before the police arrived, discharge of incapacitant sprays, use of batons, Mr. Bio's actions towards the police, the restraint process itself, evidence from Ms. Wise about a baton, and the question of identification is also noted in the final bullet point. So the focus of this note, which is more than a year before your involvement, and when any view was drafted at a very early stage of the Crown precognition process, appears to be on the precognition of eyewitnesses. And there's mention of an incremental approach, with the initial focus being on whether or not there was a basis for bringing criminal proceedings. All that said, in the bullet pointed list that we've looked at, that non-exhaustive list of matters to be addressed, Was there any mention of race or how to approach the question of race during the precognition process?
I don't see it in that list.
Okay. And was there any mention of ensuring or how to ensure that the process was Article 2 and 14 compliant?
I don't see any reference to that there
All right.
in what you've shown me.
And now that you've seen this minute, does this ring a bell with you? Were you shown this at any point to the best of your recollection, or are you perhaps seeing it for the first time today?
I don't think I'm seeing it for the first time. But I wasn't directed to it at the start, and I can't tell you when I would have seen it. Could well be after my report had been submitted to Crown Counsel. I have no idea. But I did have a review. I did have a review of the materials. I can't tell you when I might have seen that.
We'll hear from Mr. Brown later this week, and there may be a very good reason why it wasn't shared with you at the outset. It was written more than a year before you became involved. I show it to you only because we've looked at what is said in the Precognoser's Handbook about the preparation of a guidance note, and it's the only document that I have come across in my own investigations that might be described as a guidance note for the Precognoser. So I was keen to know whether that had been shared with you.
I'm not sure that was the purpose of it.
Mhm.
I wonder if I could see the top of it, because
Yes,
I
of
think
course.
I think it's a minute.
There's
to,
reference to, there's talk about a meeting, and it is in the form of a minute.
I'm not sure that was the purpose of it. So it's a minute to Deputy Crown Agents, copied to the copied to Advocate Depute, who was allocated the case. Alistair and Erin were the Precognosers at the time.
Mm-hmm. So it's in the form of a minute,
Yes.
and it references a meeting,
Yes.
and the purpose is stated as being to identify key issues to be
Mm.
explored at precognition of the relevant eyewitnesses.
Yes.
So it may be that it was intended to serve an entirely different purpose, and no doubt Mr. Brown can tell us more about that.
Yes.
You're giving evidence before he is, and I wanted to share it with you, as there are certain aspects of this that perhaps read as though it's intended to be some form of guidance to the Precognoser, but perhaps that wasn't its purpose. But we can ask him about that.
Well, just reading the first sentence or the first paragraph, it seems to be identifying issues to be explored at the precognition of witnesses.
Mhm.
So it's the topics that would be covered in speaking to the
In
witnesses.
speaking to the witnesses.
As I understand it.
Yes, rather than the process more broadly.
Yes.
Can we return to the Precognoser's Handbook, please? Chapter 1, page 7. And the section headed Continuing Role of the Solemn Legal Manager. It's important that solemn legal managers remain involved throughout the case preparation process in all cases, especially in serious and difficult cases. This will be particularly facilitated by the establishment of specialised solemn units where precognition officers will be in daily contact with legal staff. The solemn legal manager, who will have ultimate responsibility for the quality of the precognition report and will certify its contents accordingly before its submission to Crown Counsel, should assist in identifying the issues which require to be dealt with during the course of the preparation of the precognition report and be available to give guidance to precognosers whenever necessary. Now again, the language gives away that this wasn't written specifically for Cap D.
No.
But is there anything here about the role of the solemn legal manager that doesn't sit well with the procedures that were in place in Cap D in 2017?
No, although I would say this was perhaps an exceptional case. This was not a run-of-the-mill Cap D precognition. It would be unusual for Mr. Brown to be the solemn legal manager of any report. It would normally be one of the principal deputies who would take that role. So it's a case that was dealt with exceptionally, I would say.
So Mr. Brown was the head of
Yes.
the unit,
Yes.
and it would ordinarily have been one of his principal deputies, that's the grade that you're at now,
Yes,
who would take on the role of solemn legal manager.
exactly.
And why was it that he took on the role of solemn legal manager in this case? Why was this case dealt with on an exceptional footing?
I think you'd have to ask more senior members of COPFS that, the reason for that, but I know that it was his role in this particular case.
All right. Certainly, he says in his statement, we don't need to bring it up on the screen, it's not at all controversial, he says a full precognition, including detailed analysis of available evidence, was to be prepared under his supervision. So to what extent then did you receive guidance and supervision from Mr. Brown during the period of time that you worked on the analysis?
I think it was incremental. I mean, certainly my memory of the first meeting in December of 2017 was specifically, I want to involve you now in this matter. This is your role. It's about assisting Alistair in preparing the analysis of evidence, and in particular in the instruction of the OST expert who had still to be identified at that point in time.
And you mentioned that you had a meeting with Mr. Brown and that you received emails from him over the course of the period of time that you were involved that identified issues that you were to consider.
But we also met regularly.
Okay.
Yeah.
Were those meetings on a formal footing or on a need-to basis?
Quite informal. Regular chats about how things were going.
Now, Mr. Bio died in police custody, or at the very least after contact with the police, and as such both Articles 2 and Article 14 were engaged, and you, I think, acknowledged that in your statement. I wonder if we can bring up your first statement, please. And can we scroll down to paragraph 67? So we can skip across the first few lines and get to the part that begins my understanding. It's about, thank you very much, where the cursor is.
Yep.
My understanding is that Article 2 provides for the right to life and the right not to be deprived of life. By dint of Article 2, COPFS had an obligation to carry out an effective investigation into the death of Mr. Bio, since his death was in the course of restraint at the hands of agents of the state, namely the police. Such an investigation should be independent, effective, and include a thorough, impartial analysis of all relevant evidence, be expeditious, and open to public scrutiny. Although the views of the family of the deceased should be taken into account, the investigation should not be restricted to their concerns, and there should be consideration of all relevant lines of inquiry. It affected the approach to my work in that it underpinned everything I did. Much of the investigation had taken place before my involvement, but to the extent that further investigation was required, this was instructed promptly, ensuring that all relevant lines of inquiry were followed. For my part, I was concerned to obtain the necessary evidence of training materials and submit these along with the relevant statements and productions in an instruction to an expert in restraint who was independent of Police Scotland. Thereafter, I conducted a thorough analysis of the evidence about potential criminality, addressing potential individual and corporate criminality as expeditiously as possible. I had no direct dealings with the family, but was aware through the correspondence from Mr. Anwar of their concerns and did my best to address those in my report to Crown Counsel where they related to potential criminality. Then there's some discussion about disclosure. And then if we can look at the last 4 or 5 lines of that answer, please. Article 14 provides that the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground including race and colour. I was aware of this right as it underpins the impartial approach to my work and is a standard that is expected of everyone in COPFS. So you make clear in this answer to a question that you were asked in your first Rule 8 that you were aware of the requirements of Articles 2 and 14 and that those requirements underpinned everything that you did.
Yes.
And that would include your approach to the analysis of the evidence
Yes.
in this case. And you agreed with me earlier that for an investigation into a death by the Crown Office to be Article 2 compliant, it requires to be effective. So you're nodding.
Sorry, yes.
Sorry. I should have said that the proceedings are being
Yes, I should
simultaneously transcribed. So to be effective, it must be adequate.
Yes.
And you accepted too that the precognition process, including the analysis of the evidence, required therefore to be adequate in order to comply with Article 2.
Yes.
And you agreed with me earlier that when there has been a death in state custody, an adequate investigation must be capable of leading to a determination of whether force used was or was not justified.
Yes.
And the analysis of whether the use of force was justified involves asking whether the force used was no more than absolutely necessary.
Yes.
And these are issues that the Crown required to consider as
Yes.
part of its investigation. You also agreed with me earlier that when there is a death at the hands of state agents, taking Article 14 in conjunction with Article 2, the state authorities have an additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events.
Yes.
And you accept, I think, that it was the responsibility then of COPFS to take all reasonable steps to unmask any racist motive that may have played a part in the death of Sheku Bayo,
Yes.
and to pursue that line of investigation with vigour.
Yes.
So these were positive obligations on the Crown in terms of Article 2 and Article 14, and they required to be discharged through the precognition process.
Yes.
So I want to move on shortly to ask you questions about the process that you followed when you analysed the evidence and you drafted the analysis for Crown Counsel. And I'd like to ask you about 3 areas: your approach to the analysis of the use of force, your approach to your analysis of cause of death and causation, and then finally your approach to race. Now, Mrs. Carnan, can you bear with me just a moment, because we quite often take a break around about this time. I wonder, sir, I am moving on if it might be convenient to
Yes,
you.
we'll take a 20-minute break at this point. Mrs. Tomlinson.
Mrs. Carnan, as I said before the break, I want to move on now to ask you some questions around your approach to looking at the evidence of use of force in this case. Now, in any case, evidence of use of force can come from a number of sources. Those might include the statements of the officers involved in the restraint, eyewitnesses, potentially the post-mortem report as well. Would you agree?
Yes.
And in the particular circumstances of this case, all 9 of the officers who attended Hayfield Road gave statements to the PERC on the 4th of June of 2015.
Yes.
And those statements were given as witnesses and not as suspects.
That's right.
Now, we have heard evidence that a suspect should be cautioned before they're asked any questions, and they're entitled to access to a solicitor too. Is that your understanding? Yes. A witness, on the other hand, won't be cautioned, and they won't be afforded access to a solicitor.
Sorry, did you say won't be cautioned?
Won't be cautioned,
Yes, that's right.
nor will they be afforded access to a solicitor.
That's right.
And where a suspect isn't cautioned or isn't given access to a solicitor, then an issue might arise as to the admissibility of their statement as evidence against them in any subsequent proceedings.
Yes.
I wonder if we can look at the analysis, please. That's COPFS 06361. At page 7 of the PDF, please. If we can, scroll a little bit. Where that black line is, I'll be looking at the text immediately beyond that black line. Thank you. Now, there's very little in the analysis about the admissibility of the officer's statements, but I want to draw your attention to what is there. So if we can look beyond the redacted passage near the top of the screen. It is also important to note that PERC investigators who interviewed the police officers on 4th June asked them in detail about their own actions, bracket, which evidence is not admissible against them, close bracket, but were less focused in their questioning about what others around them were doing. So there's a statement there that an officer's statement is not admissible in evidence against them. And if we can look at the paragraph that follows, 2, please, if we can look at it in its entirety. The police officers only provided their statements to PERC investigators following assurances given by PERC that they were considered to be witnesses and not suspected of having committed any crime. This was at a time when PERC investigators had already obtained statements from witnesses such as Wise, Alley, Nelson, Robinson and Mullen. By that time, PERC investigators had obtained some accounts of police officers bringing the deceased to the ground and pinning him down by lying on top of him. In light of their assurances that the officers were being treated as witnesses, it is considered that their own statements could be inadmissible in evidence against themselves on the grounds of fairness. However, the accounts given include descriptions of their colleagues' actions, and to this extent, their statements can be considered as evidence for or against their colleagues. So in the paragraph we looked at a moment ago, the language used was which evidence is not admissible against them. And in this paragraph here, we see it is considered that their own statements could be inadmissible in evidence against them on grounds of fairness. Now, leaving aside the inconsistency between could and not, this is really the extent of the discussion about admissibility in the analysis.
Yes.
That they could be inadmissible or they're not admissible, and there's no explanation in the analysis at all beyond the paragraph that I've read out as to why you form the view that the officer's statements were or could be inadmissible. Is that fair? That's the extent of the discussion.
I think that's right. On
that topic. Now, are you aware, Mrs. Carnan, that there is extensive case law on the admissibility of statements as evidence against their maker?
Yes, but it's not explored in this analysis.
Yes, and I wondered whether you had considered the case law on admissibility.
to some extent. I can't remember reading up on it particularly, but I was taking a cautious approach, and I think my position is reflected in the second paragraph that you read out, and I thought that there was a possibility that the statements of the officers could be held inadmissible in evidence against them. I think the first statement is probably extending it too far. I think that's probably...
So you identified this as being a
Potentially.
possibility, a potential. There was the potential for the statements to be ruled by a court of
Challenged,
law.
yes.
Yes, challenged and found to be inadmissible.
Yes.
And for that reason, you left them out of account when
Yes.
analysing the evidence of criminality against each individual
That's right.
officer. Now, when one looks at the case law, one consideration that is relevant is whether suspicion has crystallised
Yes.
on the person who gave the statement at the time that they made the statement. Would you agree with that?
Yes.
And we can also see from a review of the case law that where a person is under suspicion, or ought to have been under suspicion, and treated as a suspect, the admissibility of their statement will depend on whether in all the circumstances it was obtained fairly.
Yes.
Would that be fair?
Yes.
So it's not perhaps as simple as saying a person was or should have been a suspect, they weren't cautioned, they weren't given access to a solicitor, and therefore their statement will be inadmissible. The case law perhaps encourages a more nuanced analysis of all of the circumstances, looking at when suspicion crystallises and the fairness in all the circumstances.
I accept that.
There's no discussion in the analysis as to whether suspicion had crystallised on any of the 9 officers at the time that they gave their statements, beyond that paragraph that we see on the screen in front of us.
That's right.
Okay. Nor is there any discussion in the analysis as to any circumstances that might point towards fairness or unfairness.
I agree.
And there's no reference to any case law. You've acknowledged that, I think, already. And there's no analysis of the likelihood of a challenge or the likelihood of a court ruling the statements to be admissible or inadmissible.
Correct.
Now, each officer played a different and separate role in the restraint, and there's no assessment in relation to each individual officer of these questions of suspicion and fairness.
Correct.
They've been considered, if you like, as a group rather than on an individual basis.
That's right.
So you appear to have proceeded, as you say, on a cautious basis.
Yes.
On the assumption that the statements of all of the officers were inadmissible, or could be inadmissible, and so you've left each officer's statement out of account when analysing the evidence against him or her.
Yes.
And you've adopted that cautious approach rather than, for example, drawing attention to the issue, analysing the case law, and including each officer's statement of his or her own involvement, with the caveat for Crown Counsel that there was a question mark over admissibility.
That's correct.
You do, however, in your analysis, consider whether each officer was justified in using the force that they used, and as part of that analysis, you take into account any explanation or justification that they gave in their statement.
Yes.
And we see that, if we can scroll down just a little bit, please, to the paragraph that's, yes, thank you, that's perfect. So you say, in addition, where an officer has provided in their own statement an explanation or justification for their own or others' actions, this may be relevant in considering whether such justification has merit and should be considered in relation to the question of mens rea. And I'm wondering whether there's an inconsistency in your approach here. If a statement is left out of account for the purposes of establishing criminality, can it then be taken into account as evidence of justification for the use of force? Do you see the tension there?
I do.
And I'm wondering whether a statement could be inadmissible for one purpose but admissible for another.
Possibly. I think that paragraph related to the position of an accused person providing a justification if they were prosecuted.
And if that accused person was prosecuted, they wouldn't be obliged to give evidence?
No.
No.
But their statement would be available nonetheless.
Their statement would be available unless there was a challenge to its admissibility. So if a person was prosecuted having given a statement in circumstances where perhaps they ought to have been treated as a suspect, cautioned, access to a solicitor and so on and so forth, and none of that happened, and their legal team were to challenge the admissibility of that statement, and that challenge were to be successful, then any evidence of justification that were contained within that statement would also fall. It would also be inadmissible because the statement in its entirety would be put to one side. Is that right?
I have to say I hadn't considered that.
But I think you agree with me that throughout the analysis, the approach that you have taken is that the statement of each officer is left out of account when you look at the evidence of use of force at the hands of that officer,
Yes.
but is taken into account in assessing whether the use of force by that officer was justified.
Yes.
And looking back now, do you think that was a sound approach to take?
I don't think it was the approach that Crown Counsel agreed with, because I recall reading Crown Counsel's instructions and the case of Gilroy being brought to attention, in which Crown Counsel effectively disagreed with my assertion.
Right. I won't ask you anything about Crown Counsel's instructions. There has been a decision by the chair that doesn't permit me to probe that. But you are of the view that Crown Counsel didn't agree with the approach that you took. And,
That's right.
and I wonder whether, if you found yourself drafting an analysis in a similar set of circumstances tomorrow, whether you might take a different approach.
Very likely.
And what would be different?
Well, I think the case of Gilroy would be one that I would refer to in terms of fairness and what constituted fairness and what constituted and the situation in which a witness's evidence could be used. It then became a suspect.
So to put it another way then, would you analyse in relation to each officer, one by one, whether the circumstances in which they had given their statement were fair?
Yes.
You say that Crown Counsel took a different view. Were you asked to revise or reconsider this
No.
part of the analysis? No. Before you drafted the analysis and adopted this particular approach in relation to the admissibility of the officer's statements, were you given any guidance on how to treat their statements?
I'm not sure what you mean by guidance.
Well, clearly you had a concern around admissibility.
Mhm.
Did Mr. Brown say to you, either off his own bat or perhaps after you knocked on his office door, that you should approach the statements in the way that you have done in your analysis?
I don't recall any discussion about it.
Okay. Do you recall seeking guidance as to the approach to take in relation to the officer's statements?
No.
And you say you don't recall any discussion around the subject with
No, I
Mr.
don't.
Brown? And looking back, would it possibly have been helpful if this particular subject had been identified, whether by you or by Mr. Brown, as a subject that might have been talked through before you embarked on drafting the narrative and analysis?
In hindsight, yes.
Let's move away from that. Now, when an officer uses force to achieve a lawful objective, for example, if they're detaining or arresting a suspect, the force that they use must be reasonable. Again, sorry, we're picking up an audio, if you wouldn't mind just confirming. I can see that you're nodding your head. Thank you so much. Force use must be reasonable. It must also be proportionate.
Yes.
It must be necessary.
Yes.
And no more than the absolute minimum required to achieve the lawful objective in question.
Yes.
Other options involving a lesser degree of force must either have been tried and failed, or at least considered and found not to be appropriate in all the circumstances.
Correct.
And that was a little bit of a mouthful, but that test is sometimes referred to as preclusion.
Yes.
An officer has to be able to justify his or her use of force,
Yes.
and they have to be able to justify every use of force. So, for example, if an officer strikes someone with a baton 2 or 3 times, they would have to be able to justify each individual strike.
Yes.
If an officer cannot justify their use of force as reasonable, proportionate, necessary, the minimum required, then that use of force will be unlawful.
Yes.
And if an officer has failed to preclude options that required a lesser degree of force, then again their use of force will be unlawful.
Yes.
And so it would have been an important part of your process of analysis to consider the role played by each officer in the
Yes.
restraint, and also whether each use of force by each officer was justified and lawful.
Yes.
And that would involve looking at the evidence of what happened, but also looking at each officer's knowledge. So that could be information provided to them over the airwaves, their observations at the scene, and also the training that they had received,
Yes.
and whether they were acting in accordance with their training.
Yes.
Now, I'd like to ask you about just 2 or 3 small chapters within the analysis. And the first relates to what in the inquiry we've called the initial contact. So that is when officers Walker and Payton arrived at Hayfield Road. And if we can look, please, at the analysis, and at page 13 of the analysis. That's perfect, that middle paragraph there. If we can go 5 lines down, please. It is clear, thank you. Do you see where I am, Mrs. Carnan? It is clear from the statements of Walker and Payton.
Yes.
It is clear from the statements of Walker and Payton that on the basis of the information to hand, they had decided to take a robust confrontational approach even before they got out of the van. Walker even admits to having considered driving the police van at him. And the inquiry has heard evidence, and it's the same evidence that was available to you, that the officers got out of the van with their sprays drawn, that they issued strong verbal commands, and when they did not bring about the desired results, they resorted to the discharge of their incapacitant sprays.
Yes.
And you have described this as being a robust and confrontational approach.
Yes.
And the inquiry has also heard evidence, and again it's the same evidence that was available back in 2017, that when Constables Walker and Payton got out of the van, Mr. Bayou was walking normally along the road, and he had his hands by his side and didn't appear to be carrying a knife.
Yes.
Now, you mention in the analysis, and this is at page 11, near the top of that page, please. You had, by the time of writing this report, a report from Martin Graves, an expert in officer safety training. The inquiry's heard evidence from him also. And I understand that by the time that you prepared this report, Mr. Brown and Ms. Edwards had consulted with Mr. Graves, but you weren't part of that consultation process.
That's right, but Alistair MacLeod and I recognised him.
You recognised him,
Yes.
and that was before you prepared the analysis.
Yes, or in the course of the preparation.
In the course of the preparation, before it was finalised,
Yes.
if you like. So, I see. So you had the opportunity of a precognition
Yes.
with Mr. Graves, and I understand that you were also involved in a consultation, but that was at a later stage. It was during the VRR process
Yes.
that we won't be discussing today. Returning to what Mr. Graves had to say, if we look at the text that follows on from the redacted passage. In his report, Martin Graves, OST expert, states that PC Peyton could have used a more communicative style to initially make contact, but he did not think that his approach was the cause or catalyst for Mr. Bio's response or behaviour. So we see here that Mr. Graves has raised the possibility of an alternative communication style, an alternative to the strong verbal commands, or what was referred to in evidence before the inquiry as verbal dominance type approach. So Mr. Graves has identified an alternative, albeit he's offered a view as to whether or not the officer's approach, the approach that they did take, triggered the events that followed. So I'd like to ask, as part of the process that you undertook, and that would include your precognition of Mr. Graves as well as your analysis, your thoughts and your drafting of the analysis, did you give consideration to what other tactical options were open to Constables Walker and Peyton when they arrived at Hayfield Road?
I think Mr. Graves did and referred to the options in his report. So, yes, a communicative, a less dominant, if you like, communicative approach was an option, but he didn't criticise the officers for choosing the more dominant. I think the words he used were hard stop, was the way he described it.
That's the way he described it in evidence before the inquiry too. So he wasn't critical of the hard stop, but he identified that there was at least one other option.
Yes.
Now, I have looked through his report, and I will be corrected if I'm wrong, but I didn't immediately identify in his report any other options that he had laid out, any other tactical options. We did, in the course of his evidence, hear about other options, and you had the opportunity to precognose him, so let me tell you what they were. I'm simply interested to know whether they were discussed with Martin Graves or considered by you during the course of your analysis. The other options that we heard about were a rendezvous point. That's where the officers go somewhere away from the immediate locus, for example, the car park at Gallagher's, and convene and arrive at a tactical plan and potentially await for specialist resources. That was one option. Another option was observe, wait, feedback. That involved observations at slightly closer quarters, perhaps from the car parked across the road or something of that sort, waiting for specialist resources to arrive if required, and feeding back to the control room. And then, of course, there's what Martin Graves has referred to as the communicative approach, which I think is referred to as tactical communications in the police training manual, and during the course of the inquiry has often been referred to as de-escalation. So on a continuum, if you like, there would be at one end of the scale the communicative approach, at the other end of the scale the robust confrontational hard stop, and in between there were two other potential approaches that were discussed with Mr. Graves. Now, I don't think they're in his report. It may be that you're hearing about this for the first time today, but I'm interested to know, you had the benefit of a precognition with him, and you've applied your mind to this during the writing of the analysis. I'm interested to know what consideration you gave to the other tactical options that were potentially open to Constable Walker and Constable Peyton.
Well, I think the important thing to get from Mr. Graves was his assessment of risk. And his assessment was that this was a high-risk situation based on the information before the officers attended. And therefore he was of the view that the hard stop was the course of action that he would have expected most police officers to adopt. He wasn't critical of it. He didn't discuss the options of a rendezvous point or standing back. My understanding was that the other resources, I think the dog unit and the armed response vehicle, were not coming anytime soon. That was my understanding. Now, I might be wrong about that, but I think that was from the police officers themselves, that they did not anticipate this assistance to come immediately. So I understood that they took the view that they were obliged to deal with Mr. Bio.
So you say that Martin Graves wasn't critical of the hard stop, and he said to you that it's what most officers, the tactic that most officers would adopt
Yes.
in those circumstances.
Yes.
Now, that may be his opinion, but the test, of course, that the law requires to be met is that the approach adopted should involve the most minimum degree of force. Other options have to be precluded, has to be necessary, reasonable, proportionate, so on and so forth, which is perhaps a different thing from it being the approach that other officers would have adopted. Do you see the distinction there?
I do.
I appreciate that you have an expert who appears to be certainly not critical of this particular course, but I'm wondering whether, notwithstanding the fact that he didn't criticise the approach, he did raise the possibility of at least one other tactical option, the communicative one, and I'm wondering whether you, in your analysis or as part of your analysis, considered whether this hard stop was necessary and proportionate, and whether other options had been precluded by Constables Walker and Payton.
I think in considering the position of the first two officers, as I say, the first point was about the information that they had and their assessment of risk, not only to themselves but to members of the public, given they had information about a large knife. That was foremost in their minds as I understood it. In terms of then their approach, the question of preclusion of other options, I think, was provided by Mr. Graves in the sense of assessing himself that it was a high-risk situation for them, and that the use of tactical communications may not have been appropriate.
But in saying that the use of tactical communications may not have been appropriate, is that sufficient to get over the bar for preclusion? Preclusion would require either that tactical communications had been tried and had failed, or that in all the circumstances it was not an appropriate option.
That's what I understood the officers to take the view, and I understood Mr. Graves to support that.
All right. And do we see anywhere in your analysis in relation to the actions of Constables Walker and Payton in carrying out the hard stop, the initial actions following their arrival at the scene, do we see anywhere in your analysis a discussion as to whether their approach was necessary, proportionate, the minimum required, and whether they precluded other options?
Certainly cited on page 12 the explanations provided by the officers, their justification for deploying PAVA.
I'm really
that's probably going further than
I think so. I'm concerned really with
the initial contact.
The initial contact, yes.
Just bear with me, I'll have a look back. Thank you. Well, I think what I do at pages 8 and 9 is refer to the information that PCs Walker and Payton have had over the airwave messages of the disturbance and of the description of Mr. Bio. and the risk assessment that although they couldn't see a knife, they assessed that he could still have had the knife in his possession. And that was an important point, I think.
Yes. Yes. So you've looked at the information they had from the airwaves, observations on arrival at the scene, including the fact that although a knife wasn't visible, it could have been concealed, risk assessment, and so on. Yes, I see all of that is in there, but I'm just wondering whether in terms you have set out in the analysis a view on this initial engagement, which it might be said set the tone for the events that followed, whether or where that initial engagement sat in terms of being reasonable, necessary, proportionate, minimum, force required, indeed whether any sort of force or combative robust approach was necessary at all. I don't see that set out in the analysis beyond the passages that you've drawn our attention to.
If it's not there, then I accept that it's not there, but I think I have laid out the information that was available to them, the reference to the training manual where they're advised to assume that there's no such thing as a low threat, so there is a high threat to them at this stage. And I have acknowledged, I think, sorry, I'm just going to try and find it. I've lost it.
Take your time.
I'm sorry, I'm not able to find it, but I think there was reference to the officers, to the fact that Mr. Bio was on one view walking along the road, acting normally.
Yes.
So I think I've acknowledged that position, you know, that we have the police coming at it from this is a high risk situation, and on the other hand we've got an alternative view of actually, on the face of it, Mr. Bio walking quite normally. I can't find where that is.
Yes, I recall seeing that in the analysis. If it would assist you, you can consider the analysis over lunch and we can revisit this. But it's before the inquiry, it's before
Yes.
the chair,
Yes.
subject to the redactions that we can see here and there on the screen. But perhaps what I should take from your evidence is that although you haven't set out the legal test in terms and how that applied to the initial engagement, you consider that all of the relevant information has been laid out in the analysis,
Yeah.
the airwaves, observations
Yes.
on arrival, risk assessment,
Yes.
the fact that Mr. Bio didn't appear to be carrying a knife, but that wasn't to say he didn't have one,
Exactly.
and so on and so forth. So
Yes.
the information is there in the analysis.
I think so.
All right. Let's move on then to another chapter in the restraint, the baton strikes by Constable Tomlinson. And I wonder if we can begin with the narrative. If we could perhaps have the narrative up on the screen, please. And if we can turn to page 25. Now, I appreciate that you didn't draft the narrative, but this is just to get a grounding before we look at the analysis. No, sorry, it's the narrative that we're looking for, please. The narrative is COPFS 06360. If we don't have it, I can work around it. We don't have that.
I have a copy of it in front
You
of
have
me.
a copy. In that case, perhaps we'll look at the hard copy. I was going to look very briefly, and just in passing, at page 25, Mrs. Carnan.
Yes.
Second paragraph from the top reads, PC Tomlinson states that after PC Short was assaulted, he ran at the deceased and struck him with his baton once to the head and 2 or 3 times on his arms.
Yes.
Okay? I just wanted you to see that, and if you can hold that thought, because I don't think what's recorded there is factually correct. And what I'd like to do now is bring up Constable Tomlinson's statement, please. It is Perk 00263. And if we can turn to the 3rd page of that document, please, and scroll down to there. Perfect. Sorry, a little bit further. Sorry. A wee bit more. Perfect. So that bottom paragraph on the screen, Mrs. Carnan,
Yes.
describes the point in time where Constable Tomlinson struck Shekbayo. I struck him with my baton once to the head. It was to the left-hand side of his head, diagonally from the back of the head to the jaw. He stopped stomping on Nicole at that point. I think I hit him again, which was about 2 or 3 times in total to the head area. He turned around and took up a boxing sort of stance with both fists clenched in at his chest. I thought he was going to attack me again, so I struck him 2 or 3 times with my baton to his arms. So we have here him explaining in his own statement that he struck Mr. Bayo once to the head with the baton, at which point, of course, Constable Tomlinson's position is that Shekbayo was stamping on Nicole Short's back. After that first baton strike, he stopped stomping on Nicole, and Constable Tomlinson then hit him again, which was about 2 or 3 times in total. So there were 2 or 3 baton strikes to the head. One which apparently caused Mr. Bayo to stop stomping on Nicole Short's back, and then a further strike or possibly 2 strikes to the head after that. Is that how you would read that statement?
Yes.
He then goes on to explain striking him to the arms 2 or 3 times. So if we can just go back to the precognition, which reads in the narrative, PC Tomlinson states that after PC Short was assaulted, he ran at the deceased and struck him with his baton once on the head and 2 or 3 times on his arms. So it seems that there are 2 pieces of information that are missing from the narrative there. Firstly, there's the fact that there were 2 or 3 baton strikes to the head and not 1.
Yes.
And secondly, there's the fact that Constable Tomlinson's account is that after the first baton strike to the head, Mr. Bayo stopped stamping on Nicole Short's back. So do you see that that information has been omitted from the narrative?
Yes.
Now, I know that you were not responsible for drafting it. This is just to get our bearings before we look at Constable Tomlinson's involvement, because I know that you left his account out of account in the approach that you took to analysing the evidence against him. So I wanted to begin by looking at that first. So if we can perhaps return to your analysis now, and you look at the baton strikes on page 20. Of the analysis. Now, you provide a very careful analysis of the first baton strike, and we don't need, I think, to concern ourselves with that. But if we could bring up, please, the analysis again on the screen. And if we could go to page 20, please. And if we can look at the second paragraph here. At page 20 of his report, Mr. Graves, in more general terms, highlights that strikes with a baton must be justified by the officer concerned, and that each individual strike must be justified and consideration given to its effectiveness against another possible tactical option. PC Tomlinson was not asked to and has not provided in his statement justification for each blow. He clarified at Precognition that he thought that PC Tomlinson, a relatively inexperienced police officer, was likely to be stressed in this encounter, and when he got no response to the first baton blow to the head, repeated that same action as if locked in to that action. Now, when you go on to analyse the use of baton strikes by Constable Tomlinson, as we've identified, there's no reference in the narrative to him striking Mr. Bayo in the head 2, possibly 3 times, nor is there any reference in that to the fact that after the first baton strike, according to Constable Tomlinson, Mr. Bayo stopped stamping on Nicole Short. And further, Constable Tomlinson's own account is left out of account by you in the analysis section. However, Mr. Graves has drawn to your attention, and I don't think this is in any doubt, that each individual strike with a baton requires to be justified. So we're dealing here with 2, possibly 3 baton strikes to the head. As I say, I'm not concerned with the first baton strike, but I am concerned to explore your analysis of the second and third baton strikes. And so far as I can see in this paragraph and elsewhere in the analysis, beyond noting Martin Graves' sympathy, I suppose, for Constable Tomlinson's lack of experience, I'm not clear that you went on to analyse whether the subsequent blows to the head were necessary, proportionate, reasonable, the minimum required, whether other use of force options had been precluded. Were those issues analysed by you?
I'm just looking at my analysis of the evidence about criminality of PC Tomlinson. I think I start on page 18.
Mm-hmm.
To establish criminality, it would have to be shown that PC Tomlinson went far beyond the limit of the force which a police officer is entitled to apply in apprehending the suspect.
Mm-hmm.
Police training on the use of force in general in Module 1 discusses the need for the officer to take account of the profiled offender behaviour and the impact factors that may apply. PC Tomlinson provides justification for his actions because of the assault on PC Short and his own perception that he was about to be assaulted. And I say at the top of page 19, he provides this as justification for striking the now deceased. And I have got actually in my analysis on the left side of his head 2 or 3 times.
Mm-hmm.
And 2 or 3 times to his arms and around the Achilles heel area. But I don't identify and don't discuss each strike individually.
Okay. And although you include his justification
Yes.
for the multiple strikes,
Yes.
do you anywhere in the analysis set out whether each individual blow was necessary, proportionate, the minimum required, whether lesser use of force options had been precluded, and so on and so forth?
No, I don't think so. It would appear that my analysis is of a cumulative analysis of the baton strikes. I haven't gone through each one.
Okay. And in particular, in your analysis, was any consideration given or any import attached to the fact that Constable Tomlinson's account was that after the first baton strike to the head, Mr. Bayo stopped stamping on Nicole Short?
No, I'm just looking. I'm looking back at my own sort of workings, and I don't see that reference in that document either.
Because any justification, once that assault came to an end, could not be based on the ongoing assault.
Sorry,
Sorry.
repeat that, please.
Sorry if it was unclear, that's a failing on my part entirely. So Constable Tomlinson, you have noted at the top of page 19.
Yes,
You record the stomp with a great deal of force.
yes,
PC Tomlinson thought that PC Short was dead and that the male was going to kill him.
yes.
He provides this as justification for striking the deceased on the left side of the head 2 or 3 times and 2 or 3 times on his arms and around the Achilles heel. Mr. Bio stopped stamping on Nicole Short after the first baton strike to the head. So to the extent that an ongoing assault may have formed part of the justification for striking him,
On PC Short, yes.
yes, that justification was no longer available after the assault reached its conclusion.
I think that's right.
So I'm just wondering whether you had analysed the blows that came after the assault on PC Short stopped separately and taken account of the fact that the assault was no longer ongoing.
I took account of the justification which he provided was that he thought PC Short was dead, but also that the male was going to kill him. So it was a perception of the risk to both of them.
All right. Now, you drew my attention to a passage on page 18 a moment ago.
Mm.
If we could perhaps have page 18 on the screen, that would be helpful. Towards the bottom of the page, please. There we are. Thank you. To establish criminality, it would have to be shown that Tomlinson went far beyond the limit of the force which a police officer is entitled to apply in apprehending the suspect. Is that the correct test?
That's my understanding based on the case law, which I think I set out at the start of my analysis of evidence.
Mm-hmm. We're not in a position to look at the case law at the beginning of your analysis today, I'm afraid, because of a decision that has been taken around the boundaries of the inquiry's terms of reference. But you agreed with me earlier that a use of force which is not reasonable, is not proportionate, is more than is absolutely necessary and more than the minimum required in all the circumstances will be unlawful.
Yes.
And I'm wondering, therefore, why you've set out this particular test. To establish criminality, it would have to be shown that Tomlinson went far beyond the limit, because far beyond the limit is a different test from reasonable, necessary, proportionate, and so on.
I understand the difference. My understanding, however, and perhaps if I'm contradicting myself now in giving evidence, but my understanding in terms of case law is that that paragraph is correct.
Right. But I think you agreed with me earlier that certainly from the perspective of Article 2, to be lawful, force must be reasonable, proportionate, no more than absolutely necessary, and lesser use of force options must have been precluded.
Yes.
Okay.
But there is I think there's a tension between Article 2 then and the existing case law.
And you make clear in your statement that Article 2 underpinned everything that you did in your work on this precognition, including the analysis. So
yes.
Insofar as there may be a tension, and as I say, I regret we cannot get into the case law around criminality, but if there is a tension between what the criminal law requires and what Article 2 decrees to be unlawful, do we see that tension set out and analysed in your analysis?
Not specifically, no.
So we should understand here that you considered that this was the application of the correct test from the point of view of considering the criminal law,
Yes.
but your focus here was on the criminal law of Scotland, or domestic law if you like, and
Yes.
and perhaps not on Article 2.
It was an understanding of the applicable criminal law
Okay.
in Scotland.
And I don't see anywhere in the analysis, but you will correct me if I'm wrong, consideration as to whether Tomlinson's actions were Article 2 compliant.
No.
Let's move away from Tomlinson, and I'd like to ask you briefly about Constable Walker. Now, it might be helpful if we look in short compass at some of the evidence in relation to Constable Walker. If we could look at perhaps page 37 of the analysis. Here we are against Constable Walker. And you look here at what each and every other officer has to say about Constable Walker's actions, and I'm concerned here with the point in the restraint when Mr. Bayo has been taken to the ground, and with the evidence that tends to suggest that Constable Walker was lying on or over Mr. Bayo's body. So if I can just pick a few examples, you quote Constable Payton. Craig Walker was lying across the chest of the guy and he saw him being lifted by him. And if we go to the next page and scroll down to Good, Constable Good provided a fairly detailed description of PC Walker's actions. She saw Walker using the top half of his body lying across the top of the upper half of the deceased's back in an effort to push him down.
Yes.
And then further down, DS Davidson. On arrival, has PC Walker lying over part of the deceased's upper body as he lay face down while leg restraints were being applied, or at least discussed. So I've cherry-picked rather than go through what each and every officer had to say, but that gives a flavour of the evidence that was available to you regarding the role that Constable Walker played in this part of the restraint.
Yes.
And you summarise the evidence at page 43 of the analysis. Where you say, at page 43, please. Down a little bit, please. Perfect. You say, in summary then, there are several witnesses who speak to PC Walker lying on top of, or at least asserting, the top half of his body over the now deceased for some period of the restraint.
Yes.
Which is a summary of some of the evidence that we've looked at, and there was more evidence that you took into account too. Now, would it be fair to say that the focus of your analysis from this point onwards is whether Constable Walker remained on top of Sheku Bayo after the point at which the leg straps had been applied and the police effectively had control of Mr. Bayo?
Yes.
And
to
indeed,
some extent.
Sorry?
To some extent.
To some extent. Well, let's look at the bottom paragraph here. In light of the lack of corroborated evidence showing that PC Walker remained on top of Mr. Bayo constantly and continuing to a point where he was fully under control, there is insufficient evidence from which it can be inferred that Constable Walker acted in a way that showed gross or wicked recklessness. So the focus seems to be on looking at whether there was evidence that he remained on top of Mr. Bayo constantly and beyond the point that control had been achieved by the police. Is that fair?
Yes.
And again, I'm wondering that as part of your process of analysing the lawfulness of Walker's use of force, I can well understand why you've addressed your mind to the question of whether he continued to apply his body weight or pressure to Mr. Bayo's body after the point that his colleagues had control.
Yes.
But beyond asking that question, I'm wondering whether you asked yourself other questions, and did you consider, as part of the process of the analysis, Constable Walker's body weight relative to Sheku Bayo's body weight?
I don't think I've specifically addressed it, but I think I've addressed somewhere in the report that he had a considerable weight.
Yes. Sorry, carry on.
I'm not sure that I would have had any expertise in commenting on that, however.
Were you aware of what Constable Walker's body weight was relative to Sheku Bayo?
I think he was heavy, but beyond that I can't remember now.
All right. I gather that he was seen by a Dr. Norrie, who was a force medical examiner, on the 3rd of May of 2015, and that report would have accompanied the PERC report, and that he was 25 stones in in weight,
It's possibly in the narrative somewhere, but I can't.
it might be, which is approximately twice Mr. Bayo's body weight. And you say you may not have had the expertise to draw any conclusion from the relative weights of the two men. Is that an issue that was perhaps explored with the expert witnesses? I appreciate you weren't involved in the consultation with the medical witnesses, but would Constable Walker's body weight have been drawn to their attention and raised with them?
I don't recall doing that. My recollection, however, was of the evidence tending to support the position that that Mr. Bayo was moving from one position to another during the course of the restraint, which had an impact on the restraint itself. Does that make sense?
Okay. And I think part of that evidence, and we looked at it when we looked at just some of the summaries from the other eyewitnesses, the other officers, was that Mr. Bayo seemed to be able to lift
Yes.
Constable Walker's body weight.
Yes.
And was the impact of that, lifting twice one's own body weight in the context of a restraint, something that was explored?
I think it was something that the experts on ABD commented on as a typical sign of a kind of showing exceptional strength was a typical sign of ABD.
We'll perhaps return to that when we look at cause of death. But returning now to your process of analysis of the lawfulness or otherwise of Mr. Constable Walker's use of force during the restraint, again, did you consider whether it was absolutely necessary for him to lie on top of Mr. Bayo?
I recall Mr. Graves providing opinion that a restraint process would always involve the assertion of some body weight. It wasn't possible to do it without asserting some body weight.
Okay. And did you consider, again, in returning to the Article 2 criteria, whether his actions were the minimum necessary in the circumstances?
I don't think that's addressed specifically in this report.
Okay. Did you consider whether his actions were proportionate?
I think the question of whether necessary, proportionate is all bound up, and again relying on Mr. Graves or referring to Mr. Graves, he talked about the need to gain control of the subject, and that the use of physical body weight was part of a restraint. It couldn't be excluded. The police officers would have to use some physical body weight in order to obtain the control of the subject. Page 43, I think I comment on Mr. Graves' comments about the range of movement of the deceased throughout the period. Lying on his front for which some of that Mr. P.C. Walker was across the body, putting a degree of pressure on him, but didn't think this could have been prolonged or sustained given the accounts from the witnesses such as Tomlinson, and I think P.C. Good as well, of bench pressing.
Okay, so Martin Graves has offered a view here that this part of the restraint involving Constable Walker lying on or over Mr. Bayo couldn't have been prolonged or sustained given accounts of the bench pressing movement by him. did Mr. Graves have the expertise, so far as you're aware, to comment on what appears to be a medical matter?
I'm not quite sure in what terms it's a medical matter. Well, he certainly he gave comment, and I understood his position to be that he was commenting about the way police restraint is performed, and the need for some physical assertion of body weight in order to achieve, in some cases. That's what he was commenting on.
And it may be that nothing turns on this, but on one reading, he appears to be saying that because Mr. Bio was able to carry out this bench pressing movement, then it couldn't have gone on for terribly long. And I'm just wondering whether that's perhaps a matter within his expertise.
I'm not sure that's what he said.
Okay.
I think what he was saying was it didn't look like he was in one position for very long. He was moving from one position to another. He wasn't in one position.
Oh, I see. Well, I may have misread what's been recorded there. But in any event, returning to your analysis of Constable Walker's actions during the course of the restraint, would it be fair to say that, again, you have focused very much on the criminal analysis here, and we don't see set out anywhere in the analysis section a discussion around whether or not this particular action, or indeed the restraint itself, was compliant with the requirements of Article 2?
I think that's correct.
I'd like to move away from use of force and ask you some questions now about cause of death, and it may be that we can make a start on this in the next 5 minutes or so before the lunch recess. Can we go to your first statement, please? And to paragraph 68. Sorry, bear with me just a second. Yes. Here we are, sorry. Articles 2 and 14 applied to both Police Scotland and to PERC. In the course of the investigation, the question of whether the use of force by the police officers who engaged with him had caused the death of Mr. Bio was explored in great depth, and the report to Crown Counsel fully addressed the available evidence on this. So you say that the question of whether the use of force caused his death was explored in great depth in the report, and the available evidence on this was addressed in the Precognition report. I wonder if we can now cut back to the analysis and to page 24. The restraint on the ground led to the death of the now deceased, although, as has been set out in great detail in the narrative, the extent to which the role of restraint contributed to the death of Sheikh Bio is not known, but cannot be excluded completely. So at the very outset, you say that the extent to which the role of the restraint contributed is not known, but cannot be excluded completely. And is that effectively a summary of your understanding of the position?
Yes and no. I think the first part of the sentence is probably misleading. I think the death followed the restraint on the ground rather than the restraint led to the death. I'm not sure that the evidence actually makes a causal link.
That's the nub of the issue, really, is whether the evidence does make a causal link. And in that regard, it seems that what you have concluded from your review of the evidence for the purposes of the analysis was that the extent to which the role of restraint contributed is not known but cannot be excluded completely.
I think that's what the medical experts concluded.
Okay.
Ms. Thompson, I think before you start on this substantial issue, we should stop for lunch and take it up at 2 o'clock.